Good afternoon, everyone. This is Trey. I will be administering the meeting this afternoon. Thank you for joining us. A couple of housekeeping items. Your phone will be placed on mute. Any questions that you might have can be answered through, or can be asked through the chat feature. At first, we're going to have you hold off on any general questions, and we'll tell you when you can start submitting those. If you have any questions that are directed towards the first speaker, you can go ahead and submit those right away. Any other questions, we'll have you hold off, and then we'll address those when we get to the end of the webinar today. So I will turn it over to you, Dick.
Okay. All right. Again, good afternoon, everyone. Thank you for joining us today. And my name is Dick Billings. Many of you I've spoken to. I own Billings & Company, and we were the firm that purchased the assets of Life Associates here almost 3 years ago. My golly, time flies. Also on the phone with me, I have Brad Barish, who is going to speak here in just a moment, who is been the bankruptcy counsel for a number of years, and he'll speak more to his standpoint on this process as well. I do want to mention two people who are not on the phone, just to make sure we got to know who all the players are. Most of you are familiar with the name of Greg Szilagyi, who was the bankruptcy trustee appointed, I believe, in 2010, but don't quote me on that, who actually then took over their Life Associates, and then he hired Brad Barish's firm, and he's in Chicago as well, to handle the bankruptcy state counsel. Karen Brandon also was not on the phone, but she was the employee benefits counsel. Again, you may very well know her name, but she was the one who shepherded the VCP application through the IRS. And again, that's what we're really talking about here, because again, we're coming to the end of this long tunnel and wanted to bring everyone up to date in terms of what they'll be able to do. So go on to the next slide, Trey. Now, as Trey already said, first of all, it's going to last probably less than an hour, but again, we want to leave it open for questions. So we're probably going to talk here for about a half hour, 40 minutes maybe, and then have plenty of time for questions. Now, Brad's going to talk about the more generalized questions, but he has to leave shortly thereafter. So if you have bankruptcy questions, you can go ahead and start asking them now. Now, you may have a difficulty in knowing for sure which is which, but if you know it's a VCP, in other words, this discrepancy thing with the IRS, you know that's not a bankruptcy thing. So you can, after Brad gets off, then you can add those questions into that. And again, that's through the chat window on your phone. All right, next slide, Trey. I wanted to add, I guess, with my son's assistance, Michael, this timeline of events, just again to review everybody to how we got to where we are today. And again, the discrepancy, which we're going to talk more about here through VCP, we're going to talk about in a little bit. But again, that discrepancy that we're going to be fixing here through the IRS over the coming weeks was actually occurred over a many number of years, through 1999 through 2008. And then they bought a different accounting system, which coincidentally is the very same one that we use. It's called Relias. And then post-2008, they no longer have these discrepancies. And again, we'll talk more to the detail here in a moment and so forth. But among many other things that you're also painfully aware of, other things were going on in Life Associates. And then on July 21st, 2010, they actually filed for bankruptcy. And so Brad's going to speak probably more to some details that I'm going to gloss over here a little bit, but then we got bankruptcy counsel, and then on May 8, 2013 was when Greg Szilagyi was officially appointed as the bankruptcy trustee, and then, of course, bankruptcy counsel, I'm assuming, followed shortly thereafter. The main asset, because of the many liabilities, of course, the company had, the main asset were the company itself, the accounts, you all, as Housing Authority plan sponsors. And so Greg Szilagyi, with assistance from Brad, went through a process of a public auction, if you will, for the assets of Life Associates, in which we were the successful bidder. That happened, I believe, in December of 2013, but it officially occurred. In other words, we officially acquired the assets of Life Associates and brought them into our company. Now, again, it's important to know that we just bought the assets. We didn't buy the stock. We didn't buy into liabilities. We simply bought the accounts, and obviously we've been handling your account since that time and so forth. And then around the same time, actually it had been occurring before March of 2014, bankruptcy counsel or bankruptcy trustee had discovered that there was a discrepancy, which again I'll discuss more in more detail in a moment. And to fix this discrepancy, the proper way or the most copacetic way to do it is to file it with the IRS, called a voluntary compliance program, where you go before the IRS, and in this case it was on an anonymous basis on behalf of all housing authority plan sponsors, and to say, IRS, we have a problem. This is how we propose to fix it. And then, of course, negotiations ensue in terms of what the IRS would accept and what they would not accept, and so forth. And the VCP is now, thankfully, coming close to an end, as well as, coincidentally, the bankruptcy estate. Next slide, Trey. So again, I'm going to turn it over here to Brad here to speak for a few moments, and he's going to speak on these three items, mostly just about the bankruptcy case overview. He may have some comments about VCP, but again, that's not his area of expertise, and so he may not do that. So Brad, take it away.
Sure. Thanks, Dick. Hi, everybody. As Dick said, I represent Greg Zalagi. He's the Chapter 11 trustee that took over Life Associates in 2013. I think he did touch on a bit of the history of the case where we sold the business to Dick's company, and before we sold it, we discovered from the employees there that there had been a discrepancy. We went in between amounts in everybody's accounts, held at principal as compared to the balances on the account statements that were sent out to all the customers. We hired benefits counsel back in 2013. She advised that typically what happens in these situations is that you immediately make an effort to go to the governmental authority that oversees the retirement plans to work out a way to resolve the discrepancy. So that's what we embarked on. First, we went to the bankruptcy court and got approval to begin that process, and also approval to put a hold on any transfers of any of the accounts out of Life Associates until the discrepancy was resolved. Unfortunately, the process took over 2 years to work out a resolution with the IRS, and I don't know if it's I didn't do that. Our benefits counsel did, and I think it's just the nature of the beast dealing with the IRS and getting things like this resolved. It just takes a long time. We did, however, reach agreement on both of the types of retirement plans that are overseen by the IRS and that are now managed by Dick's firm. I believe this summer, and as a precaution, we went into bankruptcy court last month, filed a motion with the court, and I believe served on it. Everybody that is affected by the resolution, we served our motion on everyone. And what we did was we asked the bankruptcy court for authority for Greg Zalagi as the bankruptcy trustee to sign these agreements. The IRS had insisted that he be a party to the agreements, even though Greg and the Life Associates no longer have anything to do with any of the retirement plans because we sold all of that to Dick's company. The IRS wanted both Dick's company to sign the agreement and they wanted Greg to sign it. We went into court last Wednesday. The judge didn't have a problem with that part of our motion. She did not sign the order yet, authorizing Greg to sign the agreement only because she said that they actually printed our motion, even though she had it for over 3 weeks. She actually had printed our motion the day before the hearing on Tuesday, and it was a very long motion, and it asked for a lot of things because what we're trying to do is also just close the bankruptcy case. And she asked for a little more time to review other aspects of our motion, namely in connection with certain other expenses in the bankruptcy case that we wanted to pay. She said that if she has no other problems, she'll just enter the order. It will appear on the electronic docket, and then we'll be done. If she has any problems, she said at the same time she'll let us know, and hopefully in the next week or so, and we would appear back before her to address any other issues. But it has nothing to do with the agreements. It's just that the agreements, as well as everything else, needed to close the case were tied up in that motion. So I don't envision any problems getting the court to approve it, and hopefully to getting her approved in the next couple of weeks. Once she approves that court order, I can tell my client he can go ahead and sign the agreements, and then Dick Billings Company can sign the agreements. There's some things that Dick's company needs to do in connection with the agreements and fixing the discrepancies. I'm sure that Dick will explain to everybody, but once my client signs those agreements, we're done. As Dick said, all the plans are now being administered by Dick's company, not Life Associates or my client, the trustee of Life Associates. So we're basically done, and then we'll be making distributions in our case to the creditors, hopefully by year end, and then we'll be closing this case in January. I think that there's one other thing that maybe many of you or some of you have called over the last 3 years about the case, not having to do with the discrepancy, but what it had to do with was back in 2002, I believe, the Principal Life Insurance Company, which holds all of the investments under the retirement plans, used to be a mutual company, and it became a regular corporation, and stock was issued back then and sold and held by Life Associates for the benefit of all of the customers of Life Associates, everyone that had retirement plans at Life Associates. It was about $7 million of value of stock was held by Life Associates, and during the bankruptcy case, and actually before we got involved, I think back in 2010 when the bankruptcy case was filed, the president of Life Associates at that time notified the court that there had been the $7 million 10 years earlier or 8 years earlier, and it had disappeared. The president actually was the wife of the person who allegedly made those funds disappear. That was brought to the court's attention. There was an investigation in the bankruptcy case, and the investigation said that perhaps there might have been some improprieties with respect to the handling of those $7 million. The funds were gone by the time the bankruptcy case was filed. I know that people have asked us if anybody is going to pursue any claims to try and recover the $7 million from any parties. I know that during the bankruptcy case, the former president of Life Associates, Richard Zachman, was sued. However, it turned out that he had no assets. The lawsuit was dropped by Life Associates. We know as a fact that he's got over $1 million of judgments against him in favor of another bank. So he was not a source of recovery. Our estate did not have the funds to pursue any suit. We know that certain housing authorities had hired lawyers back in 2013. In fact, they were the lawyers that got Greg Zalagi appointed and me then hired in the case to replace Mr. Zachman. Those lawyers for those certain housing authorities had tried to drum up support amongst the other housing authorities to try to raise funds to pursue recovery, if possible, of those $7 million from perhaps deeper pockets. And they never could find enough support. They also found that they had some difficulty, I think, in the validity of the claims that they had against those other parties. So the bottom line is, it's my understanding that there are no housing authorities that are actually pursuing these claims. It's not something that this estate is going to pursue. We don't have the funds to pursue, and don't believe that that there's anyone that would pursue them. on behalf of the estate. The claims, we think, belong rightfully to the individual housing authorities and not to our estate. But anyway, so I wanted to make that distinction. That has nothing to do with the discrepancy in the accounting on the retirement plans that's resulted in, this entire resolution process with the IRS and the purpose of this phone call. But that $7 million issue, which you may have gotten notice of, unfortunately, is not something that I don't think that anyone else has pursued. I do know that in this bankruptcy case, the housing authorities that had an interest in that $7 million did have all of their claims allowed against Life Associates, and those claims were filed by Life Associates for all the housing authorities. We did not object to those claims. Those claims are, I said, I think over $7 million in value. And from the sale proceeds that we've recovered in this case from the sale of these assets to Dick's Company, we will be distributing a little over, and it's not much, a little over 1% dividend to those housing authorities that have those claims. So it's certainly not much. It's not a happy ending at all. But at least we've gotten the business sold and into better hands, and now the discrepancy is going to get resolved as well. So, Dick, I don't know if there's anyone who has any questions or if it's something that I'm happy to give out our phone number. I know housing authorities have called in the past. Hopefully you have the motion we filed last month. It's got my contact information, my phone number 312-435-1050. But like I said, once the court enters this order, we'll sign the two settlement agreements with the IRS, and then probably in January we'll close this case.
Okay, great. Trey, were there any questions for Brad that came through?
No questions have been submitted.
Okay. All right. So, Brad, just one question I have for you is in terms of, and I know this is a guess, the first thing that to happen is that the judge has to approve this motion that was made last week, and that has to happen. That gives Greg approval to sign the IRS form, and the IRS form, of course, won't come the next day. So it's that in of itself is probably going to be a couple, 3 weeks at least. You think?
Yeah, I think they've been pretty responsive now that everything, not all the terms are in, but you look at the agreements, and there's just some basic information that's X'd out because this was all done anonymously. So the names of Life Associates, the EIN numbers will be filled in, but I don't think that'll take very long for the IRS to do that. And then once we get the final agreements, we'll sign them, and then be able to send them over to you for signature.
Okay. All right, and then again, for everyone that's on the call, we have a more definitive or the steps timeline here later on in the slides. Okay, Brad, I think
just we did have one question just pop in. It says, how will a housing authority know if they are eligible for the proceeds from the settlement? And then the follow-up should be any settlement. Not sure exactly what they mean there, but the question is, how will a housing authority know if they are eligible for the proceeds from any settlement?
I don't know what settlement we're referring to. The only proceeds that we've been able to collect in this case are from the sale of the assets to Dick's Company.
I think it's the 1%.
We've got those. The 1%. So the 1% dividend that's going to go to housing authorities is only going to go to those housing authorities that were listed by Life Associates in its bankruptcy schedules. Life Associates, I guess the employees had records of who that $7 million had belonged to, and the amounts for different housing authorities ranged from maybe a few $100s to I think over $100,000. And as far as whether you have a claim or not, I mean, you can call my office and I can take a look at the list and see if you're on that list. But I do know that early this year we set a claims bar date and we sent notice to all the housing authorities. If they disagreed with what Life Associates had listed, they could file their own claim, and that deadline, I think, was in March of this year, and so nobody else filed any claims. So the only claims in the case are these claims that Life Associate had listed in its schedules. And I think there's over 100 housing authorities that are listed that will get part of this 1% distribution. And like I said, if you want to call my office or email me, I can take a look at the list and see what if you're listed and what the amount is.
Okay, Brad, if I were a housing authority and I received, or I was on the list rather, of that motion that was filed last Wednesday, would that be a fair way to do it, or no?
No, we sent you notice because you're just an interested party.
I'm just saying if there was a list of there was a list. I didn't look at it exhaustively, but there was a lot of housing authorities listed there on that motion.
There were, but those housing authorities, some of them were listed because they are creditors of Life Associates. They are part of the $7 million, but there are other housing authorities that weren't around back in 2002, but they were around for the discrepancy, and that's why they were noticed. So there may be housing authorities out there that are not going to get a dividend. Basically, if you were a housing authority that was with Life Associates back in 2002, then you probably are listed as one of the housing authorities that will get a distribution. If you're a more recent one, the reason you were listed in the motion and why you got a copy of the motion was because you were probably still around in 2013 when this discrepancy was discovered, and that's why you were given notice of the discrepancy resolution.
Okay. All right. Any other questions?
Yeah, I had one more question that just popped in. What is the approximate value of the 1% settlement?
Well, it depends what your claim is. So, if the housing authority claim is $100,000 and it's 1%, it's $1,000. So that's the dividend. If you had a $100,000 claim, you're going to get a $1,000 check approximately.
Okay. All right. I think we're good to go. Thank you very much, Brad, for sharing your thoughts.
Okay. I'm going to drop off.
Okay.
Thanks, Dick.
You bet. Bye-bye.
Bye-bye.
All right, everyone. So we're staying on the same – go back to the previous slide. Or no, the same slide. I'm sorry, same slide. I'm looking at something else. Sorry. So we're looking at the VCP mandatory participant fix and the VCP voluntary employer contribution. And, again, this was part, as I said earlier, part of the negotiations. And bear in mind, some of you have a 401A plan. Of course, that's where the all employer contributions go in. And some of you also have a 457B where the employees defer. So in some cases, I'll be referring to the 457, and if you don't have one, then you're just going to have to listen along, I guess. And if you have both, then obviously will apply to you. But when the IRS looked at these discrepancies and realized that one plan has employer contributions only, I realize there's some voluntary, but mostly employer, and the 457 was all employee contributions, they separated, or the methodology is different. And again, I won't go into too much detail, but they'll be slightly different between the two. Now, in the total discrepancy, and again, I'm just going to try to give an analogy. There's a $1 discrepancy. Now, what's the discrepancy? If I added up, or had my staff do that, add up all the account balances in our Relias record-keeping system, okay, it would say there's $1 in there, collectively, of everyone's account. However, all the money, which is at principal, would not show $1. It would show 98 cents. It's like 99 cents or something. There's not a huge differential, but when you take it times the total of millions of dollars that's collectively owned by all you housing authorities, then it starts to be a larger number, and so forth. And then of that number, the majority of it, because a majority of the money is 401A employer money, that's where the majority of the discrepancy is, and then there's a little bit for the 457. Okay. Now, aside from, so within the 401A, let's talk about that first. It's in two pieces or two parts. And let me give an example. I'm a participant in the 401A, and I have $1 in my account. Now, it's the Life Associates, and now Billings, has been overstating my account balance give or take about 1%. Now, again, don't quote me on the number, but it's not a huge, but it's about 1%. So I really don't have $1 in my account. I only have 99 cents. Okay, so let's say that 1% differential. The two parts are going to be, first of all, is going to be an adjustment of the participant. In other words, and again, using my hypothetical, 50 cents of that dollar is going to get adjusted, debited, taken out, however you want to call it, from an employee account. Now, it doesn't physically take an account out of the employee account because, again, their account's overstated. But from an employee standpoint, it's going to show a negative number. So they had $1 at the beginning of the period, and this will show up in the fourth quarter. We're pretty sure we'll be able to adjust this in this quarter. So when the statements come out in January, it's going to show for each participant a negative number. Now, it's not going to be a huge one, and I've roughly calculated it to be about 0.4%. So let's assume somebody has $10,000 times 0.4%. That's $40. Not a huge number, but it's still going to be there. And if somebody had $100,000, obviously it's going to be $400 in my hypothetical. It's going to be some number different than that, but I want to assure you as we're prepping your employees to get ready for this, as you're prepping your employees to get ready for this, they are going to see this VCP adjustment, and it is going to be a negative number, although it won't be a huge one, but it will be one there nonetheless. Now, the IRS felt, and again, to no fault of your own, because obviously this was done by Life Associates over many number of years and so forth, but felt that the employee should not eat all of that $1 discrepancy or that 1% discrepancy, give or take. And so therefore, they came up with what's called a voluntary employer contribution for the other half, if you will, of the adjustment in the 401A. Go to the next slide, please, Trey. Now, this is going to show, as you can see, the VCP mandatory participant fix, and on the right side, the voluntary employer contribution fix. If you do both, and again, we'll talk more about that here in a second, if you do both, you're going to get something that we're going to provide to you as customers, certified custodial statements. Let's go back to, remember Brad mentioned the $7 million, and that was this, when Principal went from a mutual company to a stock company, they, in essence, issued a dividend. And, of course, you all never didn't get it. But had you had certified custodial reporting with a certified independent custodian, which we use for you now, called Matrix, out of Denver, Colorado, then the check would have gone, or it would have been a wire, of course, would have gone directly from Principal to Matrix. Matrix would have this big check for which they would not know who it's attributed to. Then they would have contacted Life Associates or Billings and Company and say, hey, we have this patronage dividend. What do we do with it? And we stick it into our system, and it maps it out to each respective plan and to each respective employee. When I first got involved with looking at the assets of Life Associates and then, of course, ultimately purchasing it, that was one of the certified, or lack thereof, of certified custodial statements was one of the most striking things that I found missing here. In other words, of all the other plans, and we have clients in 34 states, I think, now every one of our plans, the plan sponsor, the trustee of the plan, gets a certified custodial reporting a certified custodial statement from the custodian each year. So, for example, you have $1 million plan, and every quarter, we give you the participant statements, and you can access an overall management level report that says collectively there's $1 million in your plan. If you have certified custodial reporting, then you get that statement, which is an omnibus statement. In other words, it doesn't break it down by participant, but you would also get a statement that would say, hey, yep, we confirm that you have $1 million in your account. And to discharge your fiduciary responsibilities as plan sponsors, that's something that is very, very common and prudent. So when we get to this slide where it says VCP mandatory, that's where they're taking that 50 cents or whatever that number is out of the participant account. But the employer contribution is not mandatory, but we are recommending it. And again, we will be getting you numbers, and we'll talk about more of that in a second, what those actual numbers are to make that little extra contribution, which will then make your plan physically whole and then allow an independent custodian, Matrix Trust Company out of Denver, to then certify your statements. Because right now, everybody is on an omnibus statement, is not getting certified custodial reports, and Matrix won't even issue certified statements because, again, the numbers don't balance. All right. Okay, go to the next slide. And this is probably going to be the most important slide that you're going to see of this, and this is the next steps. And again, I realize it's a little small, but again, let's just kind of review what Brad said earlier, and then we'll walk through the steps to give you some timeline of what's going to happen here. So first slide is the bankruptcy court grants authority for Greg Szilagyi, the bankruptcy trustee, to sign the VCP agreement. And depending upon when the judge gets around to it, it's going to be, let's just say, another week. Could be more, could be less, but let's just say another week. Now, once she does that, then Karen Brandon, that's the Employee Benefits Counsel, is going to then work with the IRS to get the final draft, that one form that Brad earlier alluded to that didn't have Life Associate's name in it, didn't have the EIN because they were doing an anonymous application, and get that all together. Greg will have to sign it, and I'll have to sign it, and so forth. Now, within 2 business days, we've determined that when that happens, and again, we're pretty confident it's going to be in this fourth quarter, then we will adjust that mandatory VCP employee fix, where that 50 cents, if you will, or that half of 1% amount gets taken out of the employee accounts. Now, if an employee logs in to their account through our website, of course, they'll see that. Or if they don't, which most won't, then when they get their statements in the first quarter of January, they will show that negative number. Now, once that happens, once we do that internally, and that happens across the board and so forth, then we will, before I go to that, back up. I just got to ask myself a question here just to see if I'm going to, I'm going to do that later. Okay, never mind. So we just did the employee adjustment. Now, within 10 business days of that, then we're going to tell you the voluntary amount. And again, we'll do this through U.S. mail, through the primary contact, so you'll be sure to have that and so forth to say, okay, we've adjusted the employee account. If you want to entertain the possibility of a voluntary amount, which we'll recommend you do, of course, you're going to have to go to your board. They're going to want to discuss it. You'll probably have other questions, of course, and we want to make ourselves available for those questions and so forth. Now, at the same time as this is happening, we're also going to talk to you about the contribution for the 457 plan. Now, in fact, collectively, in other words, all these discrepancies, and I know you've seen some of the numbers, there's only 1.2 million of assets among everybody, of all the housing authorities, of 457 assets, so it's not very big. And collectively, the shortage was determined and negotiated out to be about almost $24,000. So it's not very much, but it comes out to about 1.3%. Now, again, some plan sponsors are going to have larger contributions as a percentage of the total assets than smaller, so it won't all be that, but on average, about 1.3%. So if you have only a 401A, then the only thing you have to, quote-unquote, worry about is that voluntary employer contribution. And again, it is voluntary. It's not required. In the case if you have a 457B, that contribution, which again will not be a large number because collectively it's only $23,000 for everybody who has one, that will be a mandatory contribution because the IRS deemed, because those are all employee dollars, that they need to be made up in totality on that basis instead of adjusting their account. Okay. Now, the next slide says plan sponsor, that's you all, will sign a document to either proceed with a voluntary employer contribution or leave the plan in a deficit state. And again, this is all done by Karen Brandon, Employee Benefits Counsel, and the IRS. We had no say-so really in it. We just had to, when we were told something, we just said we had to live with it, is that the IRS, by debiting the employee account, doesn't make the plan whole. Okay, which goes back to this voluntary employer contribution. But they did allow me to give some input to say it's not a huge number, so we are able to get it in the IRS language to say if the employer makes a voluntary contribution, that will be covered by the VCP. In other words, You might even ask, I should have done this earlier, maybe, why did the bankruptcy court even go to VCP? Wasn't required to do it. But and it's called Voluntary Compliance Program. The reason they did is if they didn't do it, then somebody, either Greg Szilagyi, Brad Barish, Dick Billings, Karen Brandon, somebody is going to have to take responsibility and say, oh, I'm going to figure out how to do it, and I'm going to try to do the best I can, but if somebody questions it, I just have to defend myself. Well, of course, Life Associates wasn't going to back it up, and neither was anybody else. And so the prudent thing that is done is to send it to the IRS. So the IRS, so to speak, gives us blessing so that you all, as plan sponsors, have a letter so that if there's an audit, if there's a question by an employee or their legal counsel or whatever about something, you've got an IRS document that says, hey, when this was fixed back in 2016 or 2017, the IRS blessed it. So it gives comfort not only to those involved with the Life Associates estate, but also to myself as your current administrator, but also for you all as the plan sponsor in case there's ever a question. So going back to this second line middle box, we're going to say, okay, here's the, if it's a 457, here's the mandatory contribution. Okay, so you'll have to take that to the board. We've already done the adjustment to the employee account. Now we're going to ask that you consider to make this voluntary contribution. And if you do that, then, as I showed you in the previous slide, we'll be able to make your plan whole, and you'll be able to get certified custodial reporting. That doesn't mean you won't get any other benefits that we're going to talk about in a moment, but that's critical. In order for Matrix as a certified custodian to certify reports, they got to, of course, have your account balance, all of the records that comes from our office and so forth. And you'll either choose to make the contribution or sign a document saying you were given the opportunity and you chose not to do so. Okay, so then once we get the money or you receive the document saying you wish not to do it, then we'll allocate the deposit, of course, if it's made. Again, if there are some housing authorities who are going to say, let's say there's two, doesn't matter, that don't make the voluntary contribution ever, because they could do it later down the road, ever make the contribution, then they're going to be in the same kind of pool they are now, which doesn't mean we can't do anything with you all, but there's going to be certain fiduciary things that we won't be able to offer to you because, again, the numbers won't balance. Then, once that decision has been made, let's say there's been an employer contribution, voluntary contribution, we'll allocate it, and then within 10 business days, then we're going to give a notice to the participants at each of their home addresses telling them what's going on. Now, this will be negotiated here between myself and or our firm and yours in terms of, in terms of what else we may say, such as enhancements, which I'll talk about more in a moment. Once that's done, and the employees have been notified and all that stuff, then we'll actually then map, and this is all journaling, it's all internal on computer transfers, actually transfer that money to, it's already at Matrix, but again, it's in a big omnibus account. It'll get transferred to a separate account within Matrix. So again, you'll have direct access electronically as well as getting then those certified reports. All right. Now, I wanted to just briefly, stay on the same slide. I just wanted to touch briefly. I've met with many of you over the years, talked to you over the last couple of years, met you maybe at NARO meetings and so forth, and we've talked about enhancements we're going to be able to bring. And I'll just mention them briefly here. Of course, you're going to have personal questions, which is fine. Let me make the first comment. The HGC fund, that's the fixed account. That is not going to change. Now, in looking at the marketplace, principal isn't paying, nobody's paying great interest, okay? And so they're not really, they're in the market, they're in the ballpark and so forth. So there may come a time in which we work with other firms like MetLife and CUNA Mutual, who also are very popular in these fixed accounts, who may change it, but obviously that's going to require a lot of concern, I would say, by your employees because they like that fixed account. So we're not looking to change that at the moment. However, all of your mutual funds, or they're technically called separate accounts, but they look like mutual funds, bond funds, stock funds, index funds, and so forth, have all been held by principal for Lord knows how many years. Now, Just think of your own investments personally that you might have, or someone else that you might know, and you're going to buy a growth fund and a bond fund and a target fund or whatever. Fine, you'll buy it, but they aren't going to buy it all from the same fund family, because over time, different fund families perform better or worse relative to their peers. So what we're going to be offering are two things. One is we are opening it up to non-principal funds, and in that process, we're going to hire a firm called Iron Financial, and you can look it up, IRON, Iron Financial, which is out of Chicago, and they're what's called a 3, and this is a numeral 3, parentheses 38. So the 38 is in parentheses, 338. That's an ERISA section. They are a 338 manager. What does that mean? If you're a plan sponsor and I'm an employee, the main risk in terms of you discharging your duties is deciding upon the universe of funds that from which I, as an employee, are going to choose from. Now, there's 20,000 mutual funds out there. You clearly, from a fiduciary standpoint, don't want to give me as an employee 20,000 fund choices. And I think you have 27, I believe, now, which is a little higher than we typically see. But let's just say 20. Let's just pick a number. 20 funds, okay? What Iron Financial does is actually take on, as a 338, as a fiduciary, the legal responsibility for overviewing, choosing, and monitoring those 20 funds or those 12 funds or whatever the number happens to be. And then over time, as funds fall out of favor for various reasons, they have style drift, they get too expensive relative to their peer group, the main founder of the fund leaves. I mean, there's all kinds of reasons and things that managers look at. Then that fund would get replaced. So they would take out Growth Fund A and replace it with Growth Fund B. Because we think that's what we see in our market, and what we do is the most risk for plan sponsors, because they're not necessarily savvy in the investment world, and certainly your participants aren't, and so forth. So therefore, they'll take on that responsibility, and again, at no extra cost. That will just be part of the price that you already pay. But also, as you will get this information, if you look at the list of the funds that they will buy, a lot of them might be Vanguard or T. Rowe Price or index funds, which are much less expensive than a lot of the funds of the actively managed funds that you have now, and so forth. So again, more information will be forthcoming, but I wanted you to be aware of that. Some of you have seen the color enrollment books that we produce. They're customized for you. If you haven't, then of course that's already being provided. We'll continue with the group term life insurance, which is right now through Transamerica, which most of you have the group term life. And again, Matrix, by the way, you may not be familiar with Matrix Trust as a custodian, but they're owned by Broadridge Financial, which you may not be familiar with them, but they are known as BR, Boy Rabbit, BR on the New York Stock Exchange, so it's a publicly traded firm. So they're independent of us. We don't own them. They don't own us, and they provide all of the custodial work to do that. So those are the enhancements that we'll be breaking out. So next slide, Trey. What are we doing on time? Okay, good. So, preparation. And again, you're going to have to wait till you get, obviously, documentation, but basically planning a future meeting with your board regarding the voluntary employer contribution to discuss the pros and cons, the amount, and so forth. So again, that'll be the next step. I'm hopeful, as Brad said, he's hoping that this will all happen in the fourth quarter, that once things are set in motion, now again, when does that date start? Well, I don't yet know, but it's probably going to be, it's already the 21st of November, let's say the 1st of December. It should be able to get it finished within 60 days. That's my hope. And again, you don't have that slide, but the previous slide where I showed the timeline, many of those slides are dependent upon what happens prior to it and so forth. And as Brad said, he's hopeful that the judge would act here within the next week or so, but now we've got the holidays later this week, so maybe it's 2 weeks. But again, we're not talking 3 months or 4 months for the judge to act, and these other items, again, will happen in their logical order once they all happen. Okay. Questions that have come through, Trey?
The first one may have been for Brad that came in right as he was signing off, but I'll go ahead and ask it.
Okay.
Is there any other impact other than the distribution of the dividends?
Well, any other impact? No, I think the answer is no. In other words, there's only two issues in this whole process of, I should say only two, but two that I'm familiar with, only two issues that reference or relate to the housing authorities. One is this $7 million demutualization dividend that happened in the early 2000s, which of course you're going to get 1%, so obviously not very much, but that's going to be forthcoming. And again, whether it's in the next 60 days or not, I'm not sure, but whenever it should be, whenever the bankruptcy estate is wrapped up. The other issue was this discrepancy. And this discrepancy, by the way, happened over a number of years, and simply because when they, meaning Life Associates back then, bought an investment, they booked it right away at today's price, not the price that it was actually settled on in 1, 2, 3 days later, and so forth. And so it was just thousands and thousands of little differences. And of course, unfortunately, it worked out to the fact that the statements ended up being overstated. So those are the only two items that are concerning relating to the retirement plans.
Okay. And then we do have another question that says, what is the anticipated VCP voluntary employer contributions stated as a percentage of total plan assets?
Yes, that number was, well, bear in mind there's two contributions here we're talking about. But you asked about, I'll mention both, but you asked about the voluntary employer contribution. So that was the 401A plan. And again, some are going to be a little higher, some a little lower, but I calculated it to be 0.4%. And so when I did that on $1 million, that was $4,000. So if you had a $500,000 plan, it's going to be $2,000 and such like that. Now, again, don't quote me on the numbers, but again, it's not a huge, I mean, don't get me wrong, it's still money. Don't get me wrong, I understand that, but it's not as big as I've seen with other discrepancies that I've worked with the IRS. Oh, the other one then, of course, is the 457B plan, which is totally separate, but if you have that plan, I calc that out to be about 1.3%. Again, it's 3 times larger than the 0.4, but still not a huge number. And as I said, they actually, meaning the IRS and Karen Brandon, actually figured out a number of $24,000 roughly collectively that'll have to get contributed by all of the 457B sponsors.
Okay. Another question, will Billings need a board resolution from the Housing Authority to effect the fix?
No. The fix is what Karen Brandon did was apply, and through Life Associates, apply on your behalf to do that. So now again, the fix is two things. The fix is, one, the debit from the employee account. So no, we need not any resolution relative to that. However, if you're going to make a voluntary employer contribution to the 401A, or even the mandatory one to the 457B for that matter, I guess, but any contribution, I would think it would be prudent. I wouldn't necessarily need it, but it would be prudent that you did do a resolution and memorialize that in your minutes.
Okay. Okay. It looks like that is all the questions we've received at this point.
All right. I'm going to make a couple of comments because I know we're pretty close to an hour. Is that if you have questions, of course, you should have my information. Of course, Carrie is your account manager. You can contact her. And again, I know things are going to pop up here as you're going to get more communications from the bankruptcy court, and you're going to get communications from us as well. And certainly, we want to welcome all your calls and address that. And if your board members need to call, by all means, please let us know.
Okay. One more question just snuck in, if that's okay. The
sure.
question is, can dividends received offset funds needed for the 457?
No.
Okay.
Because I'm going to tell you why. The 1% that's coming from it is that exactly a gain, is a dividend. It's not interest, it's a dividend, but it's like interest, okay, and so forth. And the correction that's been bantered about is getting corrected, well, half by employee being debited out of their account and half by employer contribution. So that's neither of those are considered gains or losses. I mean, in terms of investment gains or losses, and so you cannot offset those with investment gains.
Okay. Looks like no more questions.
Okay. All right. So, again, I want to thank you all for your time. And, again, I'll give you my number. In case you don't have it, you should. But it's 1-800-713-4529. So again, 800-713-4015. Trey, well, Carrie, she's the one who knows everything. Her extension is 3020, and my extension is 3002. So Carrie's 3020, and mine is 3002. So feel free, if I didn't address your question properly, or you have another question that pops up in your mind here anytime, of course, not just today, but down the road as well. So again, I appreciate all your patience. This has been a long effort. When I started, I've done VCPs before, and they've never lasted this long. But this was a very complicated issue. And I will tell you one other tidbit. When I talked to Principal about the Life Associates book and the lack of certified reporting and all this stuff, and Principal confessed to me that if there are billions and billions of dollars of assets held, Life Associates was the only piece that was held this way. So that's unfortunate for you all as plan sponsors and as participants and so forth, but it was something that got created back in 60s or 70s, I believe, back at Principal, and no one ever bothered to change it. So anyway, so again, thank you all for attending, and I'm sure we'll be talking soon. Bye-bye now.
Thank you.